We were just discussing sampling issues. Say I'm a young artist or a young studio owner. In this day and time, I have some software in my home or something, a little home studio. How do I know when I need to ask permission or don't need to sample, a chord or a line? How can I be prudent about that, and where do I go to find out this information?
Okay, the question of how do you sample, when do you need to ask permission, unfortunately, it's more complicated than it should be. With a sample, you want to take from someone else's sound recording. You want to take a snippet or a larger section of some kind of sound. It could be instruments, it could be voices, it could be a combination of them. You want to take that and use it in your music. The idea of taking pre-existing material and using it is an old one. It's ancient, it's revered, all kinds of styles it occurs in. Unfortunately, it's gotten to be a bit of a mess. There was, I think, a very poor decision at the Sixth Circuit in a case called Bridgeport v. Dimension. And it was the group NWA had a song called 100 Miles and Running. And they took this little guitar intro, this this three-note little quick gesture that's repeated. They took it from a snippet of a George Clinton song, and they used it in their song, 100 Miles and Running. They use it about 47 seconds in at one point, and they use it a few other times. You can barely hear this thing. It's extremely high. I've never played it for an audience, of any type of audience. I've played this in a lot of places. I've never played it for anyone who's been able to hear that sample, where it came from. I played the George Clinton song first, the first 45 seconds. Then I played the first minute or so, and no one has ever been able to hear it. However, if you really study it and it's pointed out to you, then you can barely hear this snippet. So I went to trial in the Middle District of Tennessee, in Columbia, Tennessee, a few years ago. And Judge Higgins, who was the judge in the case, and this is in U.S. District Court, said that it was not, he said that the sample does not rise to, it does not rise to the level of being a legally cognizable appropriation. He said even fans of George Clinton's music wouldn't be able to hear it. And I was one of those people who said, good, that's a great decision. But the sound recording owners appealed it, and they went to the Sixth Circuit in Cincinnati, and they heard it, and then they heard it, I think, en banc, all of them. And they reversed that and came up with a decision that said that if you want to sample, get a license. And which was a really preposterous decision, because what if you want to take 1/100 of a second, a half a second, whatever you want to take. What if you want to just take that music and then transform it? What if you changed the pitch? You lowered it so much, you raised it so much, you did the sound backwards. What if you wanted to do that? Why? You wouldn't even recognize it. It's just a building block. It's like you're taking some Play-Doh or something and creating a shape from it. You're taking something that's there, but you've changed it so much. Why can't you do that? Even the RIAA, the Recording Industry Association of America, which could easily have, they sort of are on both sides in a sense that George Clinton is a recording artist of the RIAA, and so are NWA. They could have chosen either side. They had no vested interest that I have to be with this one or that. They even said that's not an infringement. But unfortunately, this has become the law, and this has scared everyone into, it's prevented people from sampling. I mean, sampling has there's great reasons, historical reasons, musicological reasons that are really important. It is carrying on with a tradition. I mean, people do borrow, as we mentioned, talked earlier. There's nothing that's that original at a small scale. And you should be able to build on something. How fun is it? I mean, I think it's quite a fun idea to go ahead and remind a listener of a historical link. Oh, that James Brown in this context, that's interesting. Just a little yell, or a Ray Charles expression, just a little snippet. How cool is that? We as listeners think, this is great. It also, these samples can also get people to think, I keep hearing this James Brown, these snippets. Let me go back and really hear James Brown.
Yeah.
And the educational benefits of that are phenomenal. I mean, there's all these good reasons why Beethoven wasn't short on ideas when he had to take from previous composers. Bach was someone who could generate more music than anybody per square moment. You know, every hour he was writing a lot of music. When he took from Vivaldi, it wasn't because he was washed up and couldn't think anything else. He's saying, here's the Vivaldi, now here it is this way. So the idea of building on the past and the present is extremely important to most aspects of Western culture, yet you have attorneys and copyright attorneys who are just saying, I'm going to get them. I'm going to get them. They took our stuff, they're bad. And it's actually, at times, it's even racial. I've actually heard things where, you know, it's a black artist doing this. Right. And you have to, sometimes you just got to face it. Music and culture and society is not colorblind. So those things even play into it. But to me, the ignorance and the disrespect for tradition is at the core of this. Sampling should be an easier, normal thing to do. It should be made easier, should be encouraged. This decision does the opposite. It's extremely ignorant, it's short-sighted. I think it's foolish. I think the people should be ashamed.